Okay, so the video kind of gave an oversight into the work we do, some of our partners in the pro bono community, of which you are members. So welcome and thank you. We have slides and you have the handouts in front of you, and I don't obviously need to read through all of them. The mission of our office: we serve persons that identify as women or their children in family, matrimonial, and immigration matters. I work all in immigration matters. Our clients, this is a breakdown of who our clients are. It's not a prerequisite to be a client of our office, to be a survivor of intimate partner or domestic violence, but 80% of our clients are or have been. We receive a lot of our clients or obtain our clients through consultations at family justice centers. There's one in each county where we partner with DA offices and the police to provide social services and then direct referrals to law enforcement throughout the 5 boroughs. We also speak to clients initially and do intakes and set up times to figure out if they're eligible for our services through our legal helpline. And then this is what we're going to go over today. I was telling a few of you before, it's an easy joke for a trainer to make, but you obviously don't need to remember a lot of what we're talking about. It's just good to get familiar with the terms and really to know where to look. Because when you're assigned to work on a case with a partner, summer associate, there may be a moment of panic. When I first became an immigration attorney, I thought I knew a lot from law school, and then you're kind of like stuck with a lot of cases. You're primarily probably just going to have one case. So I don't think that will be the situation, but it's important to know where to look. These huge manuals we gave you, the mentors you're going to have through the firm, through inside the firm, and then specifically for Kramer, one of my colleagues, Amanda Dorschau, is the mentor. You can also email me, you can email anybody else to ask where to find things, how to do things, to look over drafts of documents. Obviously, you're going to have in-house people to look at that too, but we are there as a resource for you. And that's part of the agreement that you sign with any of the clients that you're going to work with. Will explain that you can share materials with our office, and they understand the agreement and the back and forth that goes on over email and telephone. Every once in a while in-person meetings, but that's not always the case. So you want to know the basics of immigration law. We're just going to explain agencies and things like that. The purpose of U non-immigrant status, that's the formal name. It was probably presented to you as we're going to talk about the U visa. If you're applying for it in the U.S., it's not a visa, but that's the shorthand name everybody uses. If you obtain U non-immigrant status, you can apply for family members outside of the country. If they're outside of the country, they come in on a U visa. The elements you have to prove to obtain U status, the nuts and bolts, the exact forms and documents you have to include, and then a timeline. So the timeline is always changing, and unfortunately for a lot of our clients, it gets longer and longer every year. There was like a golden age that some attorneys have been practicing for like a decade joke about. Between about 08 and 12, you could actually apply and then in a matter of months get an actual decision. Now the timeline is much longer, and I'm not going to tell you yet because I don't want to terrify you yet. So yeah, the overview of immigration law. I don't know if anybody here remembers the days of almost 14 years ago when you talked about immigration and you would say INS. You probably still see that referred to as in TV or a movie if there's agents doing something immigration related, but that's not really the case anymore. It's all under Department of Homeland Security. It's a new agency since 2003. And within that agency, there's CBP, Customs and Border Protection. They are on the border and they are at the airports. CIS, I was just there yesterday for adjustment of status interview. So they are where you apply for affirmative benefits, for permanent resident status, for naturalization, and also who you apply to for the U visa or U non-immigrant status. ICE, shorthand for them, I mean, ICE is obviously an acronym or a shorthand, but it's immigration police. They are the people who arrest persons who are removable, who have a violation that would allow ICE to pick them up, put them into immigration court, and or immediately remove them or deport them. This is important to remember. This is an important slide. This is also in your manual. This is the source of a lot of the law, what the benefits that we apply for, the arguments we make against, not against CIS, but to CIS, explaining why our clients should get the benefit that we're applying for. It's very statutory. It's similar for the statutory reason to tax law. We do use precedent decisions, as in the third bullet point, administrative decisions from the BIA and the AAO. You probably won't deal a lot with that, but there's federal court decisions that we sometimes use in our arguments. And then memoranda from USCIS, where they write internal memos that are also distributed to the public, explaining like, look, this is unclear, this is how we want to do it, this is how we're going to take the regulations that Congress mandated, and this is what the rule is going to look like for USCIS and how we grant benefits. And so it's good to generally think, how would you obtain lawful status in the United States? This doesn't cover everything, but it's like general silos that you put the possibilities into. Family. So if you're a U.S. citizen, you can apply for a variety of family members. If you're a permanent resident, you can also apply for a variety of family members. Employment-based, you may know people in jobs you've had in a job this summer in your own personal life who came here on employment-based visas or were sponsored via a specialized or unspecialized visa. The visa lottery is exactly what it sounds like. You can apply outside of the United States through the U.S. Department of State at the consulate, put your name in, and if your name is drawn, then you have to like get screened again. It's a very, very difficult process, but essentially you could eventually qualify for an immigrant visa, which is the same as a green card or permanent resident status, to come to the U.S. It's very difficult. Or humanitarian, which includes asylum or refugee status. I think we've all heard a lot in the news, or maybe through things you follow in your own life, refugees from Syria and from other countries that are affected, and the numbers are growing and growing in the past couple of years. Humanitarian also includes the U visa, which you'll be working on this summer. And so this is also good to remember, or just to keep in mind or to look back at, to get a perspective of what we're talking about. I was mentioning before the presentation started, non-immigrant status is what you're going to be applying for your clients. Non-immigrant status, usually you cannot adjust status and get permanent resident status off of that. The U non-immigrant status is kind of a hybrid, and so you can. Once you have U non-immigrant status, and I'm going to go into this, you can, after a couple of years, apply for permanent resident status, but it's typically a tourist visa, you're a temporary worker, or some other kind of limited status that you have to leave after a certain time. An immigrant, you hear the term immigrant all the time. Immigrants in America, and a lot of people refer to persons like that in the news as somebody who's born outside of the United States. But as far as a term of art and a term of profession for what we do, if you're an immigrant in the context of USCIS, you are a permanent resident, which means you can permanently reside here as long as you're not arrested and convicted of something that can cause you immigration consequences. And you can continue living here your whole life, even if you don't apply for citizenship. And then there's U.S. citizens. You can become a U.S. citizen by being born here, or if you're a permanent resident, you can later apply for naturalization. And then there's different ways to acquire or derive citizenship through typically your parents, or if you were born to one U.S. citizen outside of the U.S., possibly in a U.S. territory. It gets very technical, and even I have to look it up. So entry into the U.S., it's portrayed a lot of the time. I mean, airports were in the news back in January, right? The new president was trying very hard to bar certain persons from the United States, and a lot of those persons were coming in, almost all of them were coming in at airports with inspection. So with inspection is at an airport, but it could also be at a land border. It could be in somebody coming in from Tijuana to Southern California, or coming into El Paso from Juarez. Those are the examples that I know very well, because that's where a lot of our clients have done it if they're not able to fly here. But obviously at the airports, going through CBP inspection, making sure they have the proper entry documentation. Without inspection also is something you might be familiar with. Even one of our clients used the term, and I think we debated this internally, in the immigration community, saying somebody is an illegal immigrant or is illegal is not really preferred or encouraged, because you can get into a lot of philosophical arguments about why that's incorrect and offensive. But without inspection is if you're entering into the country, typically across a land border, or maybe you'd be called a stowaway if you snuck off a boat, but that's much, much harder to do nowadays. If you're coming across the Canadian-U.S. border or the Mexican-U.S. border. So in an area where there's not authorities checking your papers and allowing you to come in. Yeah, as I went through the immigrant and non-immigrant distinctions before, you could, sometimes for various reasons, the people who have permanent resident status have come in without inspection because they lacked the documents that they needed. They couldn't get a passport to fly in legally, even if they had the right to fly in. That is an issue we're going to talk about a little bit with minor children of our clients. So I alluded to this with the executive orders. There's been many that have come out since the U.S. has had a new president. and you know, we could talk all day about this, but just to like let you know what it means, because you know the president's tried to push through many executive orders. There's been challenges in court that have held a lot of these up, particularly the ban on immigration from 7 particular countries. Then he tried with 6 particular countries. That has been held up as well. What has stuck, and so what is the rule of law now, or the rule of procedure of what ICE is doing? It created enforcement priorities for people who have any criminal convictions, charges, or committed any criminal acts, which almost sounds, for lack of a better term, Orwellian, because how do you know if somebody committed a criminal act if they haven't been charged, right? So you can start accusing anybody of anything, and I can't speak for everybody in the room, but I assume everybody here has violated some sort of law, whether civil or criminal, in their past. Engaged in any fraud or willful misrepresentation. So if you tried to present fake documents to enter the country, fake documents to apply for public benefits, fake documents like if you're using a fake green card to apply for a job. Require the prompt removal of anyone whose legal claims to remain have been denied. So, and there's a practice now, if you've been ordered deported or removed, the authorities for a long time now have allowed people to come in and check in once a year. And if they haven't been arrested or something, it's sort of like let that stretch out over years. Now they're sort of reanalyzing that and looking to remove more people. And they are prioritizing, but they don't have more people to do this. So it's more like a statement. It's a statement of intent to detain anyone apprehended for violations of immigration law until the removal. There's a lot of people who have immigration violations in their past, and they just don't have the time or the ability to search for everybody and find everybody. We don't really know how this is going to be implemented in practice. This is just what they're saying. You know, Congress needs to, and the president has asked them to raise money for more immigration officers, particularly ICE officers. Oftentimes you're going to be presented with rumors that your clients have heard in the community about things like this, or just because of the new president, everybody's going to get deported. You're going to hear rumors reported to you. You're not going to be working with U.S. citizens probably, maybe some of their children, but even U.S. citizens have come to us terrified that because they naturalized 15 years ago, which means they were born in another country, the president is going to find a way to deport them. So there's a lot of rumors that may not make any sense if we're talking about it here today at a training, but when people hear this from their friends and neighbors who came to the U.S. from the same town, they've known the same people their whole life, who speak their language, it's very easy. Fear is an incredible motivating factor. And so you're going to hear a lot of questions and things repeated to you as if it were fact. And if you don't know, and I'm sure you were told in law school, and I'm sure your firms will tell you, if you don't know the answer, it's always okay to say, and this is a great training I got one day in law schools, if you don't know, you just say, I'm going to look into that. And you're welcome to ask me. You're welcome to ask Amanda. You're welcome to ask any of us and say, look, they're saying this, and it sounds very convincing. And, you know, many times I may not completely know, or I can say, like, that's a rumor that's been going around. So it's important to understand the context of what you're going to hear. And it's also important to know, before we place any of these clients with you, we've discussed risks with them, okay, of applying for immigration status, of what the reality is on the ground right now. Anyone who immigration already knows about is at risk. And so filing for a U visa, for U non-immigrant status, will only benefit them because it is a source of protection. It is not a guarantee of protection, but it is a tool to use to stave off deportation. Anyone not known to immigration authorities has been told, look, you've never come in contact with immigration. You came across the border from Mexico 15 years ago, never talked to ICE or USCIS. If you file for a U status, certainly they're going to learn of your presence. But we have the assurances of authorities at USCIS, they don't share that information with ICE, and they've been protected in the past by the government. If you're a victim of crime, domestic violence, human trafficking, or many of the crimes that fall under the U visa, and they are not removed if their claims are denied. We could see a change. There's certainly a lot of scary stuff being talked about, but we haven't seen substantial real changes. We advise clients not to open their doors to law enforcement without a warrant and remain silent if they're apprehended. They should only give their name. They should not show documents or answer questions, and they should have your phone number, even our phone number, your managing associate or partner's phone number, and tell immigration they want to speak to a lawyer if arrested. So that was a little extended, but I just wanted to make sure you understood that because I'm sure everybody's heard a little bit about it, no matter how much you know about immigration. It's been very much in the news. So let's move on to a case example, and this will be similar to some of the cases you're going to see this summer. This is Gladys. She was born in a small village in Puebla, Mexico. Many of our clients are from that state in Mexico. As the third of 7 children, she was often on her own. She was sexually assaulted at the age of 14, but did not tell her parents out of shame. She quit school and started working when she was 15 to help support her family. She became pregnant at the age of 16 and gave birth to a child. Her sisters and mother helped raise her son. At the age of 21, her family was struggling. They did not have enough to eat. Many people in her village were traveling to the U.S. to work and send money home to support their families. Gladys decided to do this temporarily in order to provide for her family. She had a cousin in New York who told her she could stay with her. So when she was 22, Gladys made the 3-month journey by bus, train, and foot to the United States. Her son stayed behind in Mexico. Her family helped her pay a coyote, a smuggler, to help her cross the border. When she got to the U.S. border, the group she was with was apprehended by CBP, the agency you saw up there. They were fingerprinted and turned back to Mexico. The next day, the group set out across the border again and made it through this time. Gladys made her way to Queens, New York to find her cousin. So when she's in Queens, she moved in with her cousin, and her cousin helped her get a job. The apartment was crowded and uncomfortable, but Gladys was happy to be in the U.S. and have a place to work. Gladys cleaned houses with her cousin and was paid in cash. She sent most of the money to her family in Mexico and used the rest to support her living expenses. At a party one night, she met a guy named Miguel. He was charming and sweet, very respectful, and invited her to the park and to the movies after work. After a few months, he asked her to move in with him, which she did. In 2011, she became pregnant with his child and things began to change. Miguel became very controlling and possessive. He told Gladys to stop working. He told her that she could not leave the apartment without him and took her keys away. He refused to give her money, so she had to rely on him to buy her food, which only he did if she begged him. Sometimes he made her have sex with him before he would allow her to have food. One night, she told him that she couldn't stand to live this way and that she was not getting enough nutrition for the pregnancy. He smacked her across the face and told her that he is the man and she had to listen to him. He also told her that if she ever tells anyone or goes to the police, she would be deported since she is illegal. She was ashamed of being undocumented, the term we prefer. Only spoke Spanish and did not have anyone to talk to about this. Gladys prayed that the situation would change once the baby was born. Gladys gave birth to her daughter in 2012, and Miguel continued to abuse her, but he did allow her to take the baby to the doctor. At one of her daughter's medical checkups, a nurse noticed a bruise on Gladys's arm, asked her about it, and Gladys was tearful and too afraid to tell the truth. She lied and said she bumped into something when the truth was that Miguel grabbed her forcefully and pushed her down on the floor. The nurse gave Gladys a few pamphlets about nursing and also put a pamphlet about DV or domestic violence in the packet. When Gladys got home, she read it and then quickly threw it away so Miguel wouldn't find it. About 2 weeks later, Miguel punched Gladys in the ribs when she refused to have sex with him. The baby was next to her on the bed when this happened, and she was terrified that something would happen to the baby. She was in pain, and 2 days later, she had large bruises. Gladys remembered the nurse and went back to the hospital. The nurse called ACS, Administration for Children's Services, and they interviewed Gladys. They reassured her that telling them what happened would not get her deported and could actually help her in her immigration situation. Gladys was terrified but told them what had been happening. They told her that she did not have to stay with Miguel, and they helped her get into a DV shelter. She did not return home. They told Gladys that she could make a police report, which she did. Miguel was arrested and prosecuted. Gladys met with the DA or the district attorney and received an order of protection. Gladys is happy to be out of the situation, but she is upset that her daughter's father is now out of her life. She is also nervous about her immigration status. After all of this, she does not want to go back. And so this is a long way of showing you a situation a lot of your clients will be in, a lot of my clients have been in the past 10 years. So how will Gladys get help? You know, there are some options discussed there. We can go to ACS, Oftentimes our clients have ACS contact after they've called the police, and the police have indicated that children were present during or around domestic violence. ACS can investigate the domestic violence, the police can. ACS can't do anything directly to Miguel or to the abuser except for not allow them to have custody of the children temporarily until a court makes a final decision. The police obviously can arrest Miguel, and then the DA's office can bring charges against Miguel. And then we often talk about the interrelation between these agencies, the Family Justice Center, which I mentioned. We speak to the police about what happened. We talk to the DA's office about getting copies of relevant records. So the U visa, U non-immigrant status, it really was first mentioned in the start of its creation was in 2000. The legislative intent came then. We're not going to go through every bullet point of the slide or even of the legislation, but the intent was to strengthen law enforcement, because the reality even today, but especially 17 years ago, was immigrant victims like Gladys or somebody else without immigration status are still and were terrified to speak to the authorities, because there's still a confusion of who enforces immigration law. Am I going to get arrested if I don't speak English? Is the police officer going to ask me for my immigration status? Some of you might have seen a video that went around on the internet in the last week or two of a transit officer in Minnesota asking somebody who didn't have his fare on a bus or a train, asking, the first thing he asked him, even before asking for his ticket, asked him if he was in this country illegally. And so people see that kind of stuff, and this is what that's not even a rumor. The problem is that's the reality. Hopefully it doesn't happen that often in places where it's illegal. Unfortunately, it looks like it's going to be legal in Texas now. We're not here to talk about that, but that has been a concern for a long, long time, that the U visa was intended to overcome, to say, if you're the victim of a crime, you report it to the proper authorities, typically the police, and you cooperate. In the investigation or the prosecution, there is a type of status you can apply for that reflects the cooperation and the substantial abuse you suffered. So the U visa, this is just a breakdown. If it's approved for your client, it's valid for 4 years. It allows a non-citizen victim of crime to stay in the U.S., to work, to help certain family members, and we're going to go into that, and later on, after 3 years, apply for permanent resident status, which you may know as the green cards. There's a cap, so only 10,000 people can be approved per year. Sounds like a lot of people, but that is the reason why the waiting for approval has become so long. I'm going to get into this near the end of the presentation, but if you apply today, it could be a few years before you get an answer about the case. The cap excludes derivatives or family members, so you can still include as many family members who qualify. The benefits, obviously, in 3 years after approval, you can apply for a green card. Work authorization for 2 years if you get the initial approval. Family reunification is great. There's limitations, though. You cannot petition for the perpetrator of the crime. So in this case, Miguel, I know that would seem obvious, that you would assume Gladys doesn't want to, but perhaps they will reconcile. There's a lot of cases of couples coming back together in domestic violence and intimate partner violence. Overseas travel is problematic. We're going to get into that. It's very complicated. The statutory cap is a huge problem. The waiting I'm talking about, you might wait for about 3 years until you get a notice initially of saying, immigration will say, we want to approve your case, but we don't have the visas, we don't have the spots, so you get deferred action. So that's good to have, but the president and the attorney general and several other people have talked about doing away with deferred action completely. It's not going to affect your clients right now because it's something that have to do in collaboration with Congress and a couple other agencies, but there's some concerns about changes on the horizon. When someone's on deferred action, there's a slight possibility, but it's very difficult to bring family members in while you're waiting on deferred action. So the waiting list, the waiting that I'm talking about. You've met all the requirements, but there's no spots available. You can get a work permit that's valid for 2 years while you're waiting on deferred action. Limitations, like I said, there's no safe way, no guaranteed way to travel outside of the country, and you have to renew the work permit if you've been waiting for longer than 2 years. And so how do you become eligible? And you're gonna know this well because when you complete the form, the 918 for your client, you have to check yes for all of these. Because the client would not be referred to you anyways if they were not eligible and if they did not have the required signature they need to even apply. I'll get into what that is. So you have to be the victim of qualifying criminal activity. The vast majority of the clients that you'll see this summer are victims of the crime that is listed on a specific form as domestic violence. In the state of New York, there is no crime of domestic violence. There's no statutory crime. So that can include many things from the violation of harassment to a misdemeanor of assault in the third, to felonious assault, to sexual assault by somebody's partner, to all varieties of physical assaults with weapons or without weapons. That's what a lot of our clients have experienced. Sometimes we make the argument there's a separate crime if somebody's assaulted by someone they're not in a relationship with. We try to make the argument that it was felonious assault, but we have trouble with police and the DAs authorizing that here. And I'll explain what that means in a second. And the person obviously has to possess information about the criminal activity. That's usually not an issue for any of our clients because they were the victims of the crime. If maybe they were knocked out by their partner and they didn't even see them coming, and then they ended up in the hospital and all they know is what the police told them, we use that to say that's what they know about it, or their partner did this to them before, or they read the medical records in the police report. So that's never been an issue with immigration coming back and saying, we don't think your client knows what happened. That they were helpful to a law enforcement agency, this is the cooperation I talked about, in the investigation or prosecution. So we often are fighting with the police about this because if they've arrested somebody, they typically don't want to sign the certification we need to apply for the U visa. They say, talk to the DA's office. But sometimes for various reasons, the DA doesn't prosecute. And so we come back to the police and say, look, they were as cooperative as they could be in the investigation. The statute is investigation or prosecution, not investigation and prosecution. So we often get into very technical, grammatical, and legal arguments with the authorities. If the crime occurred in the U.S. or violated U.S. laws, I can't think of great examples right now where it violated a U.S. law outside of the United States. I think I've heard of cases where there was a kidnapping of a U.S. citizen to a different country, and then through the help of local authorities and the U.S. Embassy, the child was brought back and there was a prosecution and the person was arrested. But we don't have many cases like that. And then something we often fight with immigration about is substantial physical or mental abuse as a result of the crime. How the victim was impacted, how they were affected. So clearly bruises, like the examples I was talking about in Gladys's case, that helps if you have pictures of that or medical records. Oftentimes that's not the case, and you need to show that the client attended counseling, is attending counseling, maybe get supporting affidavits from family members who can say, yeah, she used to be the cheeriest person in the world. She's always helping everyone out, babysitting people's kids, taking hours for me at the job. But then after this happened, like she never comes outside. I go get her groceries for her. You know, you got to really think creatively about how to show this so that immigration doesn't come back to you and say, oh, you know, it looks like it was just like a little dispute. They'll take like a line on the police report and take it out of context when the whole story is obviously much deeper. So a victim of qualifying criminal activity, I think most of the clients you're going to see this summer are direct victims. So Gladys, she was the direct victim of Miguel's crime. Indirect victim is oftentimes, it could be a child or a parent, but many of the cases I've worked on is if a U.S. citizen child is the victim of a crime, but they're a minor and their parent who does not have immigration status assisted in the prosecution. So talked to the police, coordinated the contact, made sure the child was available for any kind of statement needed. They can be considered an indirect victim. Many of my clients obtained a U visa or U non-immigrant status that way. Or a bystander. If somebody, we're working on a case, I think somebody's actually going to be working on a case like this summer, where it's kind of a mix of a lot of these categories, but somebody else was viciously attacked with a knife, almost died. She was assaulted, and the whole issue was an attempted sexual assault of her. And so I think the argument's going to be bystander, but also that you could also make the argument for direct victim. And a lot of the context is in your material, so you don't have to remember this. It's just you don't have to actually be the direct victim. Qualifying criminal activity, this is some of the crimes listed. It's important to note there's like about 25 crimes on the form. The attempts, the two bottom bullet points, they took off the new certifying form. The old certifying form is still valid. So a lot of the cases you're going to be working on will have the old certifying form with this language. Beginning in October, we have to use the new form. And so if anybody has a U visa certification signed after April 1st, and the date will come up again in the presentation, it's important to talk to your mentors about, aiming to send it in before the 1st of October, because immigration likes to change the forms that they'll accept. So right now, this is the way it stands on many of the forms you have. These are the common crimes our clients are victims of. I'm not going to go through all of it right now, but what is domestic violence? It's important to look back at this wheel. It's like the wheel of power and control. I've looked at this many, many times when immigration has written back to me and talked about the substantial abuse aspect of these cases and said, look, he violated an order of protection, okay? So she was a little upset or a little scared. You'd be surprised at the language they'll write back to you and just, kind of minimize what happened, because they really, and increasingly in these days of the longer wait times and the more applications, they want to deny more applications. They haven't clearly said that, but that's our understanding of the practice. And so when I get these letters, I did this 8 years ago, I did this last year, I'll look at this wheel and really try to think about my client's case. Like, say if there's a case that has no police reports, no pictures or medical records of grievous injuries, there's maybe an order of protection that the abuser violated, and sort of like go through what has happened in her life. Let's talk about her whole life with this person, how it all led up to this. We had a client who had a very, very weak case based on the crime, and then I had her write me a statement. Sometimes the client writes it for themselves and gives it to you, or you work with them to put it together, about how she met her husband, where she met him in the context. I learned through that they had met 30 years before. He had kidnapped her from another country in Central America, brought her to his country. They had kids together. Her family basically said, well, she belongs to that guy now. And then he brought her forcefully to the United States, and she suffered 3 decades of abuse. And that really gave context to what immigration was calling a very minimal crime. So it's just good to have this like in your arsenal to think about, like, how can I give context to my client's whole story? Effects of domestic violence. This may be obvious, but it's just good to think about these sort of things. When we talk about it, you got to show physical or mental abuse. So physical, we all understand what that is. So mental is like anything else: financial, sexual, emotional, verbal, name calling. If the person is just emotionally abusive and gets angry when you do stuff that he doesn't like, you can ask your client, how do you change your day-to-day? What do you avoid doing? A phrase that we like to use, because immigration will write back to us and say, did you have to walk on eggshells? It's kind of like an older term, but saying, like, did you have to walk on eggshells? Did you have to change your day-to-day life, to make it happen? There's cultural and religious implications as well. It's frowned upon in some religious communities, or depending on where you're from in the U.S. or where you're from in the world, or where you grew up in the U.S., even if you were born somewhere else, about reporting this kind of thing. In many countries, we've had clients who said, I didn't report this for years and years because of where I'm from. The police will come and say, if they come, they'll say, this is a family matter, or you should listen to your husband, or this is just a disagreement. And so it just depends on where you're from. That may be the case in a smaller town in someone's country, but if you're from the capital, that's not the case. So I don't want to generalize, but it's always important to consider where your client's from, what her experience has been, what her family's experience has been, what she knew growing up, how her parents got along. So this is very important. It's good to talk about now. It's good to think about when you meet with your clients about working with survivors of domestic violence and intimate partner violence. Be patient and non-judgmental. Acknowledge emotions, including your own, but especially what your client might be going through when you're meeting with her. Explain what you're there to do. Explain who you are. Explain that you're a law student working with a law firm under the supervision of attorneys or a singular attorney to work on this case and to really put it together and give a lot of eyes and very lofty brains and educations to this case to give this client the respect and the attention she deserves. Encourage the use of support services available for survivors of domestic violence. New York has many, many organizations that we were discussing. Oh, let me go back. That offer legal services like our office. We don't have extensive social services in our office, but there's many organizations throughout the 5 boroughs that offer shelter, counseling, assistance with public benefits and related issues. And then we have another video kind of talking specifically, we're not going to watch it here, I promise, on YouTube talking about how to work with your clients this summer. So we've been through those points. And so what is a law enforcement agency? That's obvious to everybody. You're usually going to think the police or the DA. You can get a judge to sign a U-Visa certification, which is the form we need to apply. It could be a family court judge. We often have had that done. Some attorneys have been very creative and got criminal court judges to sign it. It's like the DA's office won't sign it. Police departments, obviously. I've worked in a lot of human trafficking cases with DHS, with Homeland Security. There's a part of ICE that investigates human trafficking and actually grants temporary status to survivors of trafficking. So it's weird. If you think about ICE, it's like arresting and deporting people, but there's a side of it that I've worked closely with that is actually very helpful to a lot of our clients. The Department of Labor, New York State or US, if they're investigating crimes that happen on the job, sometimes it starts with like wage violations and other complaints. And then Child Protective Services, or in the context of New York, ACS. We get many, many U-Visa certifications from ACS. So this is just what to think about when you think about information and helpfulness. Obviously, they're going to possess information about the crime. Helpfulness, we often argue when we try to get a certification from a law enforcement agency, or when immigration writes back to us and says, well, you have a signed certification, and there was an order of protection issued, but it looks like on the police report it says refuse to give statement. And they sometimes will take that as like a refusal to cooperate, even though there was a prosecution after that. So you got to really look at what the statute says, and we're presenting it a little bit here. There's no unreasonable refusal to cooperate, and a mere detection of a crime can be sufficient. So just reporting it, the police never have to even have seen the perpetrator, arrested the perpetrator, talked to the perpetrator. It could just be the reporting of a crime. Sometimes the police are a little cynical about that depending on where they are. If it's a crime of domestic violence, the NYPD is usually relatively generous about it. And this is what I've been alluding to. To apply for the U-Visa, you need the signed Form I-918B. The trick with it, and why I'm talking about all this arguing, or advocating probably is a better term for our clients, is you need to convince the law enforcement agency to grant it. Any case you're going to work on, this will not be an issue. You have the certification. So this is a lot of like the front end work that we do and a lot of attorneys do, explaining that they were cooperative, that this is a qualifying crime, that it is in their interest. I used to work in Westchester County, and there was 40-some or 30-some police departments up there. So we would very readily get U-Visa certifications from the DA's office. They were great about it. There were some police departments that were great partners. There were other ones that had never been asked, maybe had 2 or 3 people on staff. And you'll get a variety of attitudes about this form, possibly about immigration. We've run into a lot of officials, and I'm not just singling out Westchester County, of course, if anybody's from there. But attitudes about immigration, and we've had a lot of people say back to us, I don't want to help, or I don't want to deal with immigration. I don't want to give somebody their immigration status. And so there's a lot of explaining around this form. Once it's signed, it's only valid for 6 months. If it's signed April 1st, it must arrive, the Form 918 with the signed 918B and anything else that we're going to talk about, at USCIS by October 1st. So this is the old form, or the form a lot of you are going to see. And so you want to look at the last page of it to look at the date of the signature. It's going to be in the case description. You should look at it again. Maybe see if there's any, if there's a possible confusing of the date, if somebody's handwriting is bad like my own, and say, you know, is that a 1 or is that a 4? Talk to your mentor about it, talk to your internal mentor, talk to her justice. And then if there's a debate about nobody can really figure out what the date is, you can go back to the law enforcement agency, but also you just want to go with the earlier date. So obviously, as I said, the crime has to happen in the U.S., and we have to show substantial physical or mental abuse, and this is often a bone of contention with USCIS. So these are the kind of things to remember, and this is also in your manual, just to think about. And we take this from the regulation, from memos, and then oftentimes these are the things that USCIS will ask us about after you've submitted the application. They're going to write back and say, if they question the abuse element, and they're going to say, how long did this go on? You know, you didn't tell us about the severity of the harm. So clearly, you're going to work with clients on their affidavits. It really has to be in the voice of your client. So you don't want to say, you know, start off a paragraph with saying like, I believe that the severity of the harm, you know, you don't start using terms you think maybe your client wouldn't use. Perhaps she would, but you just want to think about it in this context of, am I covering these points? Am I making it clear enough to immigration? And so you can't tell your client what to say, but it's more about asking her questions, you know. What happened? How long had this been going on? How did this make you feel this time? Did this remind you of the thing a year ago when he raped you and he said, oh, it doesn't really matter because we're together, so sex is always consensual if you're together. And then the evidence you can present. As I said, some clients you'll see this summer don't have the primary evidence that USCIS loves to see, the police reports, the hospital records. So you really got to think creatively. We've tried to gather everything we can from the client, but you can also think outside the box about family members or friends or neighbors, coworkers who can provide a supporting affidavit to really explain the abuse. That's usually always an issue for people without the primary evidence. Domestic violence is a qualifying crime, as I mentioned. It's not a statutory crime, so you need to really put it in context of domestic violence. Why is the harassment domestic violence? Why is the violation of the order of protection domestic violence? Why is banging on the window at 3 in the morning and trying to break into our house? Why is that domestic violence? Because she is not a stranger. They were together for this amount of time. They have a child together, et cetera, et cetera. You really have to make it clear. Just you try to avoid getting letters back from immigration because that's honestly half of the ones they send to us are them buying time so they don't have to make a decision. Yeah. This is the form that you're going to fill out. This is the petition for the U visa for U non-immigrant status. The old form that will expire in October is 8 pages long. The new one is a couple pages longer. They typically ask about the same information. And so we have here and in your manual samples. I think some of the samples in the manual are updated. But it's good just to look at this about what to fill out. For the client's address, for their actual address up near the top, we typically say confidential. And then for the mailing address, you just include your law firm. This will be, you know, a topic of conversation throughout the summer about how to fill these things out. These are examples of how to answer some questions. There's many, many questions about arrests, about criminal charges, about how you enter the country. There's a crime that this is how we prefer to answer it. We recommend you answer it. You know, it's a very broad crime, and I kind of alluded to this before with the executive orders. Have you ever committed a crime or offense for which you were not arrested? For Gladys, she entered the country without inspection, and I'm going to talk about this later on. We think you should say unclear. You know, you can say no, but I think everybody honestly can say yes. Gladys can honestly say yes. And in her context, even if she hadn't been shoplifting and never arrested, that's not what I'm talking about. You would talk about, well, I entered the country without inspection, got arrested and removed, and I re-entered without inspection. I'm unsure if that is a violation of criminal or civil law, but I know that I probably broke some kind of rule. And there's a way to describe that, and you can kind of play with the description as you work on the case this summer. Many of our clients will be able to say yes to the question about public assistance. Almost any client who's undocumented really has not been eligible for public assistance, but you need to talk to them about if they have children, especially U.S. citizen children, or any child, even if they don't have immigration status, because they are entitled to Medicaid in New York State. And also, if they're a U.S. citizen, they're entitled to food stamps and other benefits. So it's important to say, like, yes, I receive benefits from my U.S. citizen or otherwise qualified children. And then there's also a question about fraud. If you're not 100% sure, like if Gladys didn't enter the U.S. with a fake visa at the airport, it may be unclear. If it's unclear, I think it's usually good to say unclear as opposed to no, because with the U visa, there's a very broad waiver. So anything you're even kind of admitting to, as long as it's not like running an international drug cartel or hijacking airplanes or being Osama bin Laden's right-hand man, like you're probably going to be okay. We'll go through what cannot be waived. So this is a recap. You got to show all those elements, and also you have to show that you're not inadmissible, so you're admissible. And what that means is you don't have immigration violations. You don't have things that would prevent you from getting the U visa. So if you're inadmissible, beyond this graphic, these are the concerns a lot of our clients have. When I said, Gladys entered without inspection, so you're present in the U.S. without admission. You were not formally let into the country by the authorities. You could have criminal convictions. Even you could have none of this, but if you didn't have a current passport, that is a ground of inadmissibility. Some of our clients can't afford to get a passport. Some clients' countries, I know Russia is a recent example, will not allow you to renew your passport, at least at the consulate here, if you can't show that you have legal immigration status in the U.S. And so even if you had it and you came in and you overstayed, then it's very hard to renew it sometimes. So fraud can be an issue. You could falsely claim that you were a U.S. citizen. You've been removed before, perhaps in Gladys's context, and then all unlawful presence. If you were here for a long time without status and left the country and you triggered a bar. So you want to go through this analysis. Basically, you're going to go through that form we just showed you, the 918. If there's any affirmative or unclear answers, then you can kind of circle back to that, and then the materials in the manual, and go through this analysis. Like I said, there's very few things that can't be waived. If you were a guard in a Nazi prison camp 70 years ago, it's probably an odd context that you're applying for a U visa right now, but you don't qualify for a waiver. Or if you've been implicated or guilty of genocide in a more recent situation, or commission of torture or killing without government approval. And so you're going to want to show, like, yes, I entered without inspection and I've been deported, but you also want to show that discretion should be exercised for you. And so you file this second form. These are the two big forms, the 918 and the 192. It's really just a waiver. It's got a very long name, but it's a waiver saying, government, please forgive these immigration discretions or violations, indiscretions. And so how do we show that the government should approve it? We show that your client is not a risk to the United States, that perhaps if there's a criminal violation, it was shoplifting when they were 16, or you just try to really minimize what the crime was. Show the reasons for seeking admission or for seeking to stay in the U.S. For Gladys, she has a child here, she has a child in Mexico that she would like to reunify with. Hardship to her U.S. citizen child in the U.S. And community ties, her cousin, her job, people she knows, like the example I gave, she babysits for friends or picks up people's hours or is just a generally good person, goes to some sort of religious institution. Immigration loves that kind of stuff. So you show anything like that. It sounds cynical when I say it that way, but you just want to really get the whole picture of the person. In Gladys's case, Miguel was removed because of the crime that occurred. Her child has special needs. She's from a poor and rural area, and her mother, who's taking care of her child in Mexico, relies on her income to support her child. So you kind of show all this, like if Gladys is denied and you put it in the context of if she is removed or unable to get this immigration benefit, perhaps she will no longer be able to support these dependent family members. You put it in kind of extreme terms. Immigration understands that she may not necessarily be removed, and that hasn't been our experience if you have a denied U visa. So you just really try to encourage them to approve this. Okay. So the evidence we include, there's an affidavit from the client, the documents for some of the evidence we talked about, letters of support. So even if you don't have family members or other people who know about the crime, you could get a letter from her pastor, from her boss, from anybody. I mean, from her boss might be a little shaky because if she was working there without authorization, oftentimes we discourage that. You don't want to like get a letter from the boss saying, yeah, she worked for me under the table, off the books, whatever. So anybody else who can support that she's a good person, that her child goes to the same daycare as mine and she's great and she participates and all that kind of stuff. Reports on country conditions. If you have a report for Puebla particularly, or if she's from a country where you can show she'll be returning to a very dangerous situation in general, particularly for women. There's several countries in Central America where it's very dangerous for women, where they have the highest rates of homicide in the world. Honduras, Guatemala, and El Salvador. And then talking about the hardship to her child in the U.S. This, you don't have to remember this. Just look back at this slide. We have this in the manual as well. There's a part of this waiver form that says where you want to enter, when you want to enter, how long are you going to stay in the U.S. You just say not applicable, because you can use this from outside the U.S. or inside the U.S. So it's just good to clear that up. And then there's a question on page 3, do you think you're inadmissible to the U.S.? If you're using the 192 form, you're going to say yes if you determine your client's inadmissible. I think there's a few clients I can think of right now who won't need this form, who just came. There's clients who came to the U.S. on tourist visas or other visas and overstayed. And if they didn't intend when they came here, like they're like, I'm going to get this tourist visa, go to the U.S. and live the rest of my life there. If they came and then circumstances changed, you can show that, or they explain that in their statement. I came to the U.S., but then I met this guy. We started living together, and then he locked me in the house. That's an extreme example. If they don't require it, they don't require it. So there's a few clients you may see this summer that will not need this. But most clients will, typically for the entry without authorization, or we oftentimes say, like, if Gladys's child had come up from Mexico with her, or later on, if she had paid for their entry at all, for the child's entry, you would want to waive human smuggling. It used to be treated a little differently, but USCIS allows you to waive so many things on this application that you want to waive this ground, because this is the best chance to waive it for moving forward. Like, say if your client gets a U visa, they can apply for their green card. It's not an issue at that point, and it's not an issue when they apply for naturalization. So it sounds kind of weird. How can you accuse somebody of smuggling their child? Because it used to be framed in the context more of, do you work as a coyote on the border, taking $5,000 a person to take them across the river? But yeah, those are some examples. But there's other examples in your manual. And I think if it's okay, I'll give everybody 7 minutes. Does that sound good? Yours? About what? Oh, because
That's like rain. Yeah, he was like, every time like my drink would get lower, he's just like, I'll just bring you another one. I'll pay you for.
So I got to think. I'll tell you after this who it is. I don't think you can assign
Yeah.
But I'm like, no, it's important to have so the attorneys know what you said, because of misrepresentation. I remember from interviewing her like 6 days. Sometimes you forget to top line, and I was like, oh yeah, she's got a lot of. Oh my god! So I just reminded myself. I got
Get ready. Yeah, that was like the one that really threw me off. I was like, oh, I guess we're doing this.
Yes. Really?
Oh yeah. Where's mom? Yeah, I went right after. Yeah.
Yes.
Right out.
And now you're going. Just
Yeah. How
Oh, yeah.
Yeah, we don't know exactly.
I realized that when I was doing the last week.
Oh, definitely.
And it's like, I was like, I don't even need to change some of them because a lot of them could be using different forms. It depends on the expiration of the certificate. We should change that form, and then everybody got mad, and they were like, okay, we'll back up to date.
Yeah, some people are like, oh,
Oh, good.
Well, that they were talking about yesterday. Obviously,
yeah, I have litigation.
Oh, yeah. I don't know if that's, it's supposed to rain, so. Like, that'd be awesome. Yeah.
But yeah, we'll get better weather. It's like nice out, but.
Do you know what the for having? Yes. Can you have to wait a few minutes? Okay. I don't know who my.
Crappy, like.
You're gonna have a case of Jesus.
Right now.
I don't even know anything
But
about
if it's a one-time thing,
that.
if it's domestic violence, you just show the relationship. Yeah.
And then it did it.
Like, or it's okay. Like,
It might pack more power for the adjudicator, but it's like, we've had cases. You know, but the issue with that isn't so much like a CIS can approve it, it's like law enforcement, the crime. Will they have records that can confirm stuff from it? Will they have any officials there, especially the police or the NYPD, hiring like, that will remember anything about it? If they can't read the notes, it's like, you know, if things are computerized, it's very hard sometimes. So that's where we've had issues, but it doesn't, as far as qualifying for the benefit, you get the fine sponsor.
You're,
1940.
okay.
But then that person might not apply.
Okay, I'm editing a partner's picture about citizenship. So I'm having a lot of ideas to do with my partner.
Kind of work you ever doing this?
Yeah, it's actually the partner like what if that's exciting, but maybe I didn't have to be there.
Definitely, is that what you want to do?
Your gut.
Capital markets. That's why, that's fine. You know, you are, right? That's what she recommended.
Well, yeah, you can show that's like,
about the rights of the
because
service,
a lot of families, you're right.
Yeah.
And they're like enablers, so, yes. I mean, a lot of times, I'm looking right now.
I don't mind having a friend who just took this. I mean, you can give my email. I'm a friend who took it with me. And I can send you mine too. I mean, the rules are the same, but that's how you come in.
I'm just saying, you could do
Yeah,
that.
you let me know. I mean, it's and from what I hear, Julie, it's more like, I do it with feel.
You wouldn't have to show them.
Right? You're holding on, and he's like, well, you go to 389, 142 for the definition, but don't forget to set it to 145. And he's just like jumping around, and you're writing it. And you're like, I'm going to review this, and I actually have time to like read and like, you know, the stats and everything like that. So there's like different facts. But I mean, from what I hear, my friend, you know, said it's fair. No big surprises. Mine was 100 multiple choice, and he put his own in-class jokes on the
Many things about
Inspired?
Oh, yeah. Oh,
yeah.
How was he? He's Austrian, right? Or something like that? How was he?
Oh, he's a beautiful facial boy. And,
Yeah. Red Gentile for mine, and I swear by her, but she was essay. But the problem is, like, the fact that it was 4, like, almost long, legal-sized pages. Like, hour and a half. She's like, what claims does X have against, like, you know, what are all claims here?
That's that's
like, I mean, it was comprehensive, it was thorough, but it's like,
think, why we can use family court judges. It's right, the family.
no, not at all.
You're a
Yeah,
lesbian.
yeah, but I do, yeah, I think they
Like the mirror image.
would be nice. But the problem is that there's like a speech
I made that argument.
tremendous, but, I did 30 pages for Gentile, for independent study and trading. So like, it's just something comparative to kind of created in Europe. Because everything's codified, right? Yeah, so I already have 30 pages written, right? And it's like, it's basically the concept of like, they're going to have like tax, for like 4 hours, for like 2 days on Thursday, so they'll have it up to 6 final paper, already bam. Yeah, just all the tests are passed out. So my GPA check was my last time.
They're like really.
I'm waiting for one more, so it's
Then
great
you
to
just like
do
write
today.
very there's no
And they like update it like midnight.
case or something. I mean, that is the case, it's kind of typical California. So, yeah. Thank you.
No, they're
Right next to the World Trade Center.
That is terrifying. I feel like, the court,
But not everyone.
I know what I'm doing.
people did.
Okay. Yeah, so that's because we have like the use of like the water and everything. Really nice officers.
Other
That's distraction.
Yeah.
Yeah.
For justice.
Or just like doing docs too.
Yeah.
Yeah.
For,
Yeah, we work a lot with them, yeah. Oh, no, we've been doing VAWA too.
they have some.
Like, VAWA? Yeah, I mean, it's a different kind of immigration status. We've been doing that at other firms. Those are the big cases.
One more person in our class.
Yeah.
We're a smaller class.
I do a lot of immigration.
There's like 150
Places, I can like walk down. We're like at Broadway. I can walk down right by the water, yeah.
There were 3 people who were first years now. They gave out the offers.
Okay. I think you have to go to all of them. I'm kidding. And they're all today, yeah, no.
Whatever. I mean, rotation, that does sound like.
Oh, 2 years.
Oh, 10 years. Oh, okay.
I was at a similar office in Westchester for years. Yeah.
We just knew you wanted to do that.
Yeah, I did legal services immigration work in St. Louis, Florida, so I did a bunch of this stuff in law school.
Are you talking?
Yeah. Yeah, I took my bar briefing at this law school. Pretty awesome. Are you from here?
I'm actually from
Thank you. You might get your pro bono.
Are you going to law school?
I go to, I'm upstate.
I felt like I did this last
You ever seen the office?
No, actually, I haven't watched the outfit.
No?
No.
Oh, this is the character, right?
Oh, yeah.
No, the U.S. one, Ed Helms or whatever. Yeah, the character, there's a guy on there who talks about going to Cornell.
No, it's Cornell. All right.
I'm not making funny. It's just funny. Like the way he talks about it. No, my neighbor.
Can't believe that was the office. My roommate watched like the best.
He's like, when I was at Cornell. Yeah, it's like the way he drops it.
Yeah, like just unnecessarily in the company. Yeah, no, at Cornell, the Ivy League.
Yeah, it's not particular to Cornell. It's just like.
My roommate likes like religiously watching. We'll just
Scott Nelson.
you have to do that.
He came out, right?
But I figure I'm not.
Kind of like low IQ, but like
Maybe an hour. It's like it's past 2.
maybe I'll
I was like, maybe we can afford it.
I like it, but that's pretty depressing. Right? Yeah, where it's like it's good, but you're like, oh god. Okay, no, it's great. It's great. Yeah.
I'm not. I need a little.
I mean, yeah, Robin Wright is great. I think she's the best actor in the show.
Everyone remembers her.
Yeah.
I was telling my roommate that.
Oh my god, she's like, I've seen her in other stuff, but she's really, she was made for that role. Yeah.
Where did you say you?
That's saying a lot.
Or like right.
Yeah, he's good. He's always comfortable. Yeah.
Oh, so I'm working. I think we're just gonna take the BB down to Fulton.
All right, guys, I'm gonna get started again. Some of you might be wandering in and everything, but I didn't promise, but I'm gonna try to get you out of here before noon. We had talked a little bit about qualifying family members. This is really a very rewarding part of our work. It takes several years now for many of our clients, as I said, to even get to get the actual use status that you can bring your family members in on, will take a little while. So unfortunately, you may not see the end result of this, but the attorneys managing the case probably will. You have in your materials who a qualifying family member is. So for many of our clients, it's actually the category on the right. If the principal petitioner or the applicant is 21 years or older, they can apply for their spouse or their children being anybody who is 20 or younger at the time that they apply. And then the child's age is frozen at that date because there's a fix made several years ago because immigration understands that this takes so long. If you apply for your 18-year-old kid, the case takes 5 years, then technically they're not eligible when they're 23. So they freeze the age of the kid. We've had some clients in the past who are under 20. They can apply for their spouse and children as well, but also their parents and their unmarried siblings who are under 18. And so anybody who's like, the child definition of the unmarried siblings under 18, ages freeze at the time of filing. So eligibility is two-pronged. You have to be a qualifying family member, as we discussed, and also not be inadmissible. So you got to go through the same analysis for any of these family members, particularly if they're in the U.S., but also if you're applying for people outside of the country, it's good to ask, has your son, has your spouse, has your parent ever been to the U.S.? Because maybe they came here 20 years ago to work. Maybe they came here to go to Disney. Maybe they came here to do whatever and got arrested, never told them, and maybe they need to find out now before you apply for immigration status, and that possibly gets denied for the family member. If a surprise like that came up for a family member, that doesn't really directly affect your client as long as they didn't lie about the crime or something like that. If they're like, oh, my son got arrested in Mexico, I don't want to tell USCIS about it, they'll never find out. Then they find out somehow, that could be a problem. So, full disclosure. Derivative petitions, we recommend, especially in the program you're in this summer, is to submit them at the same time or soon after the client's filed. I would just say the same time. These petitions can't be approved until the actual U petition is approved, and they are not subject to the statutory cap. There's ethical considerations to think about when we talk about family members that you can apply for, okay? You may work with derivative family members who are here in the U.S. and come to meetings to fill out forms, write affidavits. You want to think about dual representation or multiple representation and the duties that you owe to clients. This kind of sounds a little bit like law school. If you've gone through ethics yet, you're going to deal with this on the bar. You're going to deal with this with your day-to-day, everyday practice. But who you owe the duty of loyalty and confidentiality to, it's to the client. We say on here, so the derivatives as well, but you have to remember, and we put this in all our materials, you have to recall who the principal client is. If there's a dispute between the principal and the derivative, you should talk to your mentor about figuring out a way to refer the representation of the derivative client out. Because there have been conflicts of interest in the context of once somebody comes on a visa and has been reunited with their parent, they haven't seen them for 10 years, they're living with grandma somewhere, and then they're like, oh, you're trying to tell me I can't go out after 10 o'clock, or you're trying to tell me I have to go to school. There can be huge conflicts that really come to a head when there's reunification, or if they just came without inspection. When families come back together, or there could be other disputes that don't involve reunification, you just want to talk to your mentor in-house, but also to us about it. You probably have language in your engagement letter that you've had for pro bono clients in the past that your firm has that you can use so the client, explain it to the client so they understand it, so if something does come up, of course everybody says nothing will come up, but things do come up. This is what the petition for the family member looks like. It's the first page. It also, the one you can use will change in October. It's available now, but you'll see the preferred examples in the manual. If the family member is in the United States, we advise that they sign the petition as well as the petitioner. So this is just a blow up of like where the qualifying family member will sign. And so this is like, that's applying for the status. That's the general concept. But when you apply for U non-immigrant status with that 918 form, the first one I showed you, that serves as an application for the U visa and for work authorization. So like I said, if it's approved in the end after a couple of years, that results in a 4-year work authorization card. But we also advise, even for principals now, because of this long wait time, the deferred action I talked about, even for principals, you're going to include a work authorization application. And the categories in there in the examples, it's called deferred action C14, so that if and when they get on this wait list that gives them deferred action, then a work authorization card comes at the same time. It's great to get that letter saying, we want to approve your case, it's been pending for 2 or 3 years now, there's a cap, but here's deferred action. But then that you don't want to have to call you wouldn't want the attorneys here then in a couple of years to call the client and say, hey, come in, we'll apply for work authorization now, and then you can wait another 2 or 3 months. It's good to have it in there, to have it all in the file, so that if and when deferred action comes, the principal and the derivatives can get work authorization. The derivatives also, so if you're applying for derivatives in the US, they're going to need 2 applications for work authorization, for deferred action, and then for the eventual hoped for 4 years of a U visa. And those are the categories talked about below. And you put the category in at number 16. There's a newer form that just has the signature page on like a second page, but the numbers are the same. And so it just shows where you put the category, and the categories will show up in the work permit. For the waiver, if your client is inadmissible, or for the work authorization, you're going to need to, for many of our clients, because they qualify for our services, they qualify by income, and they make under the poverty guidelines or around there. And so applying, or paying for over $600 for a waiver application, or I think it's over $400 now for the work authorization, it's a hefty fee, and some clients will say to you, well, should I just pay the fee? Should I get a money order and pay? Like, I know you're saying I can do the fee waiver, but is that going to hurt my application? Are they going to take my application and put it in a different pile and kind of sit on it for a couple more years? And you can assure clients, your partner and mentoring attorneys can assure them that that is not the case. I would say 95% of my clients have waived all the fees because they really could not afford it. I've had clients who've come to my office with a money order that they borrowed money from a bunch of their neighbors to pay for. And I said, I often ask people, it's a difficult conversation because you don't want to insult people, and a lot of people want to pay for things. But then I've asked them if they're like, what should I do? I'm like, I can't make the decision for you. But for example, if you paid this total of, let's say, $1,200 for you and your kids and stuff, how would you pay your rent next month? And just, I'm not saying like make the decision based on that, but you give people context. It's like this waiver is available. It's not going to hurt your case. The vast majority of people do it. There's forms that people have used and that many attorneys still use. The 912 is a fee waiver form, and then another worksheet you kind of include. I generally say don't use that. There's an affidavit you have examples of in the manual. It's just like a shorter affidavit. I am applicant. I was born this date in this place. I have so many children. I either work or don't work. My children either get public benefits or don't. I have support from this other source or I don't. And then this paragraph will describe my monthly expenses. My rent is so much, and usually the income and expenses add up a little bit. You'll be surprised. The expenses are substantially higher than the income. And you can even ask them to include some context, like it looks like your expenses are more. How do you get by day to day? And they're like, well, credit cards, or well, I'm borrowing money from somebody, or well, okay, yeah, that's right, I get money from this other thing. But you'd be surprised how many people really qualify for this. The timeline. So this could even change by the end of the summer. It's been over a year, I think, since immigration has changed what they've said. Online, you can check processing times on the government website. They are saying right now, a U visa petition received in June 2014 is being adjudicated currently. So what that means is if you applied sometime in the summer of 2014, and this has been my experience recently, your client will probably be getting deferred action. So ballpark that is saying perhaps 3 years until you get that first answer. A good way to describe this to clients and put a positive base on the whole process, because people are used to waiting for different things. With immigration status, it's not unheard of to wait for years. But it's good to explain, as I often do, is look, hopefully, and this is not a great possibility, but perhaps maybe Congress will increase the numbers 1 year. It doesn't look likely considering who's in Congress now and who the president is. But at least you'll have something in the works. So like I said, you can use it as a lever, some kind of tool to combat any ICE enforcement action. We've also been making pretty successful arguments with public benefits here in the city that even if you just have a receipt notice saying, look, I applied for the U visa last year, I have no other form, that's not even status, it just said I applied, you can qualify as a person residing under color of law. It's a category for public benefits. You can qualify for Medicaid and cash assistance. And so Medicaid is a huge thing because a lot of people otherwise don't go to the dentist or go to very expensive medical services. And so there's possible public benefits and then just like not guaranteed protection, but just something to have and to hold in case of contact with the immigration authorities. So you just want to go by this timeline we generally advise. The first week, call your client, set your first appointment, and then you're going to want to look at the file, just get to know the client's story, the crime, what happened, how many children you can tell the client has, if any. Sign the retainer and explain the process. So you're going to want to go through these materials. Don't just go based off of what I'm saying. Look through the manual, look through the PowerPoint again. Keep the timeline in front of you because that's often going to be the question. How long is this going to take? And again, back to the fee waiver. Can I really file a fee waiver, or is this some kind of trick for the government to say I'm taking money I shouldn't take or something like that? You'd be amazed, like I said at the start, the kind of rumors that people hear. In the first month or two, so June, July, really aim to file. I was talking about that changeover in October. Definitely talk to your mentors about it just to get a little more specificity about what I'm talking about. But really for your purposes, you're only going to be here probably, for 10 weeks, 8 weeks. So really aim before 8 weeks is out to file. Always with your eye on the deadline for the certification that it's only valid for 6 months. Interview your client before you file. You have to get everything together, prepare everything we talked about, really get to know the case. Before you meet with your client, ask them questions about things you're confused about. And file with the Vermont Service Center. So that's the address we still use. They've told us in calls and meetings that we can use some other kind of acronym, but we just still use this. The Vermont Service Center is the big office for the East Coast for immigration, where you send applications for green cards, depending on the category, but U visas, T visas, different things that we file for clients. And it's way, way up by the Canadian border. It's like half an hour from Canada. Once a year, they host an open house. I got to go a few years ago and see how they do stuff and meet some people. It's interesting. It's an enormous, it's several buildings where they have adjudicators who look through these files day to day to day, make decisions, send out letters. You can track your case. Once you file, there's a receipt notice that comes in the mail after a couple weeks. They'll have a receipt number in the top left. It starts with EAC for Eastern Application Center. And you put that into the case status prompt on the USCIS website. Sometimes now with U visa cases, you even put that in and then they say there's some readout that comes on that says, we can't read this, we don't understand, because they try to keep these super confidential. For instance, if like Miguel in the previous case called immigration and said, hey, I want to know what Gladys is applying for, this and that, there's strict confidentiality where they can't tell anybody over the phone if it's not the attorney or the applicant. But then even now online for checking the case number, it's kind of hard to see it immediately. You can sign up for updates for your email where you'll see when there's case action. That's something you can do if you can show that you're the representative, so perhaps the attorney on the case can do that. About a month after you file, you'll probably, a couple of weeks to get the receipt notice, and then a month you'll get the biometrics, which is a fingerprint appointment notice. The office in Manhattan is by Varick Street, so way downtown, where anybody over the age of 14, derivative or applicant, has to get their fingerprints recorded on the computer and their picture taken. Anybody under 14 doesn't have to. And then there will be fingerprint cards mailed to you to send to the derivatives abroad, if there are any who have to be fingerprinted. Talk to your mentor about setting up appointments at the U.S. Embassy to do that. Because it just depends on the embassy and what they want you to do. You can get a request for evidence like I was talking about, where immigration writes back to you and they say, we don't think there was enough, you suffered enough abuse. I know that sounds like a pretty cruel and contradictory statement, but that's oftentimes, they're going to phrase it a little bit more nicely than that. Or they're going to say, we got your U visa certification 6 months and a day after it was signed, so you need to get us another one. Or they will say, this is not a qualifying crime. It could be something questioning your case. or you didn't send us a waiver for this ground of inadmissibility. It's something they think that you need to submit, and you usually have about, they say, 87 days to respond. You would contact your mentor and go through a strategy about what to include. Probably meet with your client again. You know, I ballparked it and said 3 years for deferred action. I think we're hopefully saying 24 to 36 months, 2 to 3 years, would be issued by a pretty plain letter. We recommend you file the work permit application at the same time this summer so that a work permit would come, but if you hadn't, the attorneys at the firm would then do it. Work authorization would be for 2 years. Some firms, I can't remember with the firms represented here what the agreements are, but we have other firms we work with where that once the client gets deferred action, they terminate representation and we continue representing the client. It just depends on like the availability of associates and partners. And then this is again very open. Approximately 4 to 7 years after filing, you would hope that your client would have received the U visa, U non-immigrant status. There's no interview. So at the local immigration office, it's all done through sending documents back and forth. It would be a grant for 4 years. If denied, there's a way to appeal it within 33 days. But if your client gets U non-immigrant status, if we're going by 4 to 7 years, so hopefully in 2021, so then in 3 years after that, in 2024, they could apply for permanent resident status for a green card. There's a few things you have to show there. And again, this is repeating that there's 4 years of status. You should really note for your client, this probably will not be up to many people in the room, the expiration date of the status, just so you tell them like, you can apply for a green card in 3 years, but please do it before the end of the 4 years because otherwise you'll lose status. Also working with derivatives abroad to get visas to come into the country, and then you talk about, again, applying for a green card. I talked about travel limitations. You're going to get this question a lot. People will think, once you've applied for the status, does this mean I can travel now? You'll get questions that will seem so obvious to you, not even involving international travel. I had a client ask me yesterday, like, who was under the assumption, who has a permanent form of status here, who thought she could not leave the state of New York. So you're going to have people who are just terrified of getting on an airplane to go to Chicago, or riding in a bus to go down to the beach in Delaware. So it's really, you may not get that question, but a lot of people are going to ask you about leaving the country to go see their child, to go see their parents, to attend a funeral. Generally, for anybody you're talking to this summer, talk to your mentors, of course, but the answer is it's not a good idea. But again, it's important to tell people you can't make decisions for people. It's just you got to tell them what's going to happen. If you leave the country, for almost anybody you're representing, they're going to trigger a bar that has to be waived, and the case gets much more complicated, and they're going to have to process the application from outside the country. If somebody gets their U visa and they're able to travel, there's different ways to arrange that you don't have to worry about right now. We tell people, yes, you can leave the country, but you have to get back in within 90 days. And if you make more than one trip, you can only be outside of the country for your total 4 years of status for less than 180 days. It gets very, very complicated about getting permission to come back in. We've had clients who've done it successfully. I had another client who left after a year of status and was stuck outside of the country for 3 years. And then she was able to get a visa on her second to last day of status, entered the country the night her status was expiring, and then we luckily got it extended. But that's like an exception, and so we just tell people, even if you have a U non-immigrant status, that is not direct permission to travel. These are resources. Again, like I said, it's not important to remember everything I'm talking about today, but it's important to know where to look for things. I was talking about addition dates for forms. There will be examples in your manual, but it's also good to look at uscis.gov, and they have a forms page. And for each form you click on, there's an addition date. And you just kind of look at that and just check, like, the form you're filling out. Is this the one we need to be doing right now? Do I need to get a newer one? Am I using an example an attorney at my firm sent me that they used 4 years ago? It's not as, they just made a lot of changes in December, January that confused a lot of attorneys. A lot of us complained, and then they pushed back the date till October when there's going to be new forms required. So really, for most of what everybody here is doing, just check the government website and make sure you're using the current form. Immigration court for most of your clients that's not relevant, but if they have an A number and they've been in immigration court for deportation proceedings, you would call that number to check if there's a decision. And then the two bottom things, there's one is a phone number, the other one's an email address. I usually use the email address, so it's like if you filed with the Vermont Service Center and you have a question like, we got this receipt notice, but my client's name is way wrong, or we never got a fingerprint notice, or there's some other question you want to ask them, you can email it there, but I would recommend using that lightly, because if you use it a whole lot, they're not going to respond to you. So you just kind of try to really use it when you got to use it. And then any questions, you're welcome to ask me now. This is the contact information for myself and my colleagues. If you're at Kramer, Amanda Dorschau is your mentor for the summer, but I will take any calls or emails. Esther and Susanna will as well. And so we are the immigration attorneys at Her Justice who would know most of the answers to the questions you have, but you'd be surprised. You probably ask us questions. And the advice I've given you, like, I'll look into it. Sometimes I won't know either. So thanks a lot. Let me see. Wow.